items to cover before we get started. First of all, we will be recording this session and we will be emailing that recording to all participants following the webinar. We will also be emailing out a quick survey that we ask you to complete following, again, the webinar, and your feedback will help us to continue to improve our learning series for arts facilities in Ontario and beyond. You can also note that you can hear us, but we can't hear you. Your microphones have been disabled for this webinar, but you can use your speakers or headphones to listen in. You can also adjust the sound by clicking on the speaker icon at the top of the meeting room in green. Lastly, we will have a few minutes at the end of the webinar to answer any of your questions that you might have. We ask that you use the chat box in the bottom right to type in your questions, and we will try to get to as many as possible before 1 o'clock. All right, so moving on. My name is Alex Glass, and I am the Program Manager at ArtsBuild Ontario. In case you have not heard of ArtsBuild, we are a nonprofit arts service organization that provides programs and learning opportunities that help make Ontario's arts facilities more sustainable. One of our programs is the Learning Series, which is a series of webinars, workshops, and resources that support our core programs, which are, of course, Spacefinder in Canada, the Arts Facilities Mentoring Network, Asset Planner for the Arts, and our energy conservation programs. I would now like to hand things over to our partners at Work and Culture to introduce them and as well as our guest speaker, Shalina. So over to you, Steph.
Thank you, Alex. Looks like my mic is working okay. I can't hear me, so hopefully all of you can hear me. And my name is Stephanie Draker. I am the Program Manager with Work and Culture. Work and Culture is very pleased to be partnering with ArtsBuild on this learning series. In case you aren't already familiar with us, Work and Culture is an art services organization, and our mission is to support the career development of people who work in Ontario's art and culture sector. We go about this a variety of ways. Some of you may already be familiar with our very popular job board. We also offer business skills training and other professional development programs, which you can learn more about through our website. I'm very pleased today to introduce Shalina Ali, who has practiced law at Eiler Campbell since 2011. She acts as general counsel for charities, nonprofits, and cooperatives on a range of issues related to corporate governance, transactions, and review of contracts. She also serves on the board of directors for a Toronto area charity. So without further ado, I'll ask Alex to enable Shalina's mic and ask her.
Shalina should be able to speak. I think she has her microphone enabled.
Yeah, it should be working, I hope. Hello, everyone. Welcome. Thank you for joining me this lunch hour to discuss commercial leasing. This is not necessarily the most exciting topic, but I hope that I can illuminate a few important points about this as we go through. I've tried to distill this down in very simple ways because it is a very complicated area of law. But if you find it too simple and you have more questions you would like to ask, I am happy to answer them at the end. If you find it too complicated, please just let me know and we can discuss an issue that's come up that you're not clear about as I go through this. So just as a kind of preface to all of this, we work both for landlords and tenants who run arts organizations. I've really done this from a tenant perspective of things that tenants should think about when they're entering into a commercial lease. My advice and things that the landlords should think about would probably be different. So this is really from a tenant's perspective, and I hope that's, works for most of the people who are attending today. So here's the overview. I've kind of broken this down into a three-part process of what you're going to go through if, as an arts organization, as a tenant, as an artist, you're looking to enter into a commercial lease. So the first part is you're going to want to negotiate the terms, and this is probably the most important part of any commercial leasing arrangement, and probably the most time-consuming. The second part is when you actually take possession of your leased premise, of your unit, of your space. It's going to be how you occupy it, what your responsibilities are with respect to the landlord, and what the landlord's responsibilities are with respect to you as a tenant. And the third part is termination, which is just basically the things that you have to consider when you want to get out of your leasing arrangement.
Shalina, sorry. Thank you for the overview.
Yeah.
I'm just getting some feedback that your microphone's just a little bit buzzy. I'm wondering.
Okay.
I know it's a little bit tough, but if there's anything you could do to mitigate it, totally fine. We'll just keep on going.
I am not entirely sure. Let me just. How's that? Is that better?
It's about the same. Yeah. So you might need to back away from your microphone just a little bit. You know, Caleb actually has a good suggestion, like turn down the sensitivity in the settings. But regardless, let's just keep on moving forward, and we'll do our best to.
Okay. I've done both things Caleb has suggested, so I'm hoping.
Oh, that sounds way better.
Hoping it's a bit better. No problem. Okay. Okay, so let's get into it. So what is a commercial lease? It's really a contractual arrangement. So, you know, a lot of people are familiar with your residential tenancies and your residential lease, and a commercial lease is a lot different than that. So while there is a piece of legislation that can apply to commercial tenancies called the Commercial Tenancies Act, it's pretty basic. It doesn't really have a lot of protections for tenants, and it can be overridden by an actual lease agreement. That's unlike in the residential tenancies context, where there's a piece of legislation that really protects a lot of the tenants' rights, so protects the tenants against rent increases above a certain amount, protects their ability to stay in their residential unit, and protects them from the landlord entering at all hours of the day, things like that. That's not provided for under the legislation that deals with commercial tenancies. So you really need to negotiate all those things as part of your actual commercial lease, so your agreement. And that's why the lease agreement is so important. And again, a lease, and this is something that comes up, I do feel, for a lot of arts organizations and artists, is the difference between a lease and what a lot of people have, which is a license. So a lease, the term lease is important because it provides a tenant with exclusive use and occupancy of a space, and which is different from a license, where it's more the ability to use a space but not exclusively, and it doesn't include an ability to basically exclude others from that space and decide who can enter that space. So that's kind of the difference, and I do feel like some of you might encounter that kind of distinction between a lease and a license. So commercial lease is really a distinct type of contract or animal. So again, as I said, your lease agreement is really what you're going to need to look to know, what your rent is and what's included in it, how much your rent can increase from year to year, from month to month, and what access rights your landlord can have. So how much notice does your landlord need to give you to enter the space? Can the landlord enter at any hour of the day during Monday to Friday? Do they have to give you notice? Things like that. And also the length of your lease. So how long is your lease? When can it terminate? Are you allowed to stay in the space after it's been terminated? So all those things are things that are going to be set out in your lease agreement and aren't going to be found in the piece of legislation called the Commercial Tenancies Act. So here's the first part, negotiating the lease. So there are two types of leases generally that a tenant and landlord will negotiate. And the types of leases are important in terms of basically how much you're on the hook for in terms of cost. So there's a gross lease, which I like to refer to as the all-inclusive option, and then the net lease, which is a carefree option to the landlord. So what a gross lease or an all-inclusive option is really that you as the tenant have a idea of how much it's actually going to cost every month to lease the premise, because it's going to be a fixed price. So it's basically going to be a lease that says, for this space, you're paying $1,500 a month, and that's it, and that's all. And there might be HST on top of that if it's not explicitly included in the amount in the lease, but otherwise, that's all you're expected to pay. A net lease means that the landlord basically doesn't want to carry any of the costs for operating the building where your space is located, or for paying for property taxes or anything like that. So a net lease will basically have two components to the amount you're going to pay. You're going to pay a base rent, which is going to be fixed, and it's often based on the square footage, so $12 a square foot, for instance. And then an additional amount, which is going to be all of the operating costs that the landlord might incur in operating the building and operating the space. And so the amount that you pay can vary from year to year and month to month, depending on what those additional costs are. Now, there are some hybrid versions where, for the most part, it's it's a fixed price, but then there are some additional things. So you'll pay your utilities, for instance, or you'll pay for your proportionate share of the landlord's insurance costs or things like that. So the amount of rent per month that you're going to pay isn't going to vary by that much, because it's not going to be all of the operating costs, but there are going to be some additional costs other than just the rent set out in the lease agreement. So here's a sample clause from a net lease, which is a lot of fun to read. And I'll read it out loud. It's a mouthful. So, it is the intention of the landlord and the tenant, and it is hereby agreed by them, that the tenant shall pay all rent to be paid hereunder to the landlord without any deduction, abatement, or set-off whatsoever, and notwithstanding any statutory or other provisions, all charges, expenses, payments, and costs of every nature and kind whatsoever incurred in respect of the demised premise, or for any matter or of thing affecting the devised premises, shall, unless otherwise expressly stipulated herein to the contrary, be borne by the tenant, so that the rent herein provided for shall be absolutely net to the landlord. The landlord shall not be responsible, just in case you didn't know, for any charge, claim, or liability whatsoever in connection with the demised premise, except as expressly provided in the lease. So this is a very, mouthful provision from a net lease, which basically, what does it mean? Well, it means that the landlord's not going to pay for anything, and the tenant should know that just in addition to its base rent, its costs for the operating the building or the premise are going to vary from month to month, and they're going to be responsible for all these additional types of costs. So negotiating the lease, it sounds still okay. Sorry, I hear that there's a comment about the sound, but I think people have said it's better.
Yes, it is much better.
Okay, all right. So negotiating the lease. So the first point when you're negotiating a lease is you're going to want to set out what the key business terms are. And often tenants and landlords, especially if you're using like a realtor, will enter into an offer of lease or a letter of intent, and that's going to set out the key business terms. And then after that, there's going to be a lease agreement. And the lease agreement is the legal document that encompasses the key business terms, and that's going to be what binds the parties when they actually enter into the leasing arrangement. So your offer to lease is really important because you want to set out those key business terms in that way. So, in your offer to lease, the first thing that you're probably going to want to decide is what kind of rent are you paying? Are you going to be in a gross lease? Are you doing a net lease where you're going to have basic rent and additional rent? If you're going to have a net lease for additional rent, what kind of documents are you going to have access to from your landlord if you want to verify that all of those operating costs were actually paid by the landlord and something that you as the tenant are responsible for. And I would highlight this as a really key point because this is often the area where after the fact, once people have entered into the lease agreement, there's a lot of conflict around additional rent and what is adequate evidence or adequate documentation from the landlord of the costs that they've incurred in operating the premise or the lease space that the tenant is ultimately responsible for. So that's the key item that you're going to want to deal with in your offer to lease or the business terms that you're negotiating when you're negotiating a lease to begin with. Other things that might be relevant to your rent is the landlord going to provide you any incentives? So any rent-free periods, for instance. If you're doing a lot of work on the premise and you as the tenant are responsible for doing work to make the space usable, are you going to have to pay rent during that work period where you can't necessarily operate, but but you're going to need to be in the premise and occupying it and carrying out work? So those are all things that relate to rent that you're going to want to figure out in your offer to lease. And the last thing is deposit. So how much is your deposit? How long is the lease? If your lease is pretty long, so about 10 years, and the landlord is holding a deposit that's significant, say 5 months worth of rent for that 10-year period, it's often being held without interest. So, what does that mean for you in a business sense? Are you willing to take that hit in terms of putting a large deposit up front and then having it be held by the landlord for that long a time? So other things to consider when you're negotiating the lease is how you use the space. So this is actually a really important consideration because you want to make sure that what you plan on doing with the space is something that the landlord understands, is set out clearly in the lease and in broad enough terms that it can encompass all sorts of activities that can be related to it. So for instance, if you're renting a gallery space, but you also want to run classes, does the use that you've agreed upon with your landlord kind of encompass that additional use of the space? You also want to make sure that there aren't any zoning requirements that might prohibit you from using the lease space in that way. So if you're kind of doing a lot of industrial work or work that uses chemicals or things like that, you'd want to just make sure that it's a permitted use for that space in that location in that building. If you're renting space in a condominium, you should look at the rules of the condominium and see if what the use that you're proposing is permitted under those condo rules. So, use is a really important thing, and you want to make sure that all the potential uses that you've considered using the space for are incorporated into your lease. Common areas and access. So another thing that you want to think about, there are going to be common areas that you're going to need to have access to allow visitors, guests, other individuals to enter the space and to leave the space. There are all sorts of accessibility requirements that businesses now need to have. So is the building accessible? Who's responsible for ensuring that accessibility? And is that clearly set out in the terms of your lease? Signs. Where do you want the signs? Do you want them on the outside? Do you want them on the inside? Do you want them near the elevator? Again, this is something that's important, and a lot of landlords don't want signs on the outside of their building advertising to the outside world who the tenant is and what they're using the space for. So if that's important to you and you want to be able to clearly show from the outside where you're located, then that's something that you're also going to need to include in the negotiation of terms. Hours of operation. So there are leases where the landlord requires you to operate, 5 to 7 days a week from the hours of 8 to 5 p.m. So you want to make sure that that actually makes sense for your business. There are also provisions in the lease which might make you pay more if you decide to operate after hours, so after regular business hours in the evening. So you also want to understand whether or not that applies to you and how that's going to affect your bottom line. And then repairs and maintenance. you want to get an understanding while you're negotiating the lease what you're responsible for in terms of repairs and maintenance and what the landlord is responsible for. And you want to, in terms of assessing the space, you want to know how that's going to impact, again, your bottom line and what costs you're going to have to bear if the space, does require a lot of repair or might require a lot of maintenance throughout the term, and that's your responsibility. You want to make sure you have enough money to pay for that. Okay, and then finally, the other bunch of legal stuff, improvements. So a lot of spaces, as you can see in the picture, will just kind of come as empty spaces and will require specific improvements that you as a tenant need in order to basically carry out your use or your business in that space. So those improvements do need to be negotiated before the lease is signed, and the lease should include very specific responsibilities about who's paying for the improvements, what improvements are going to be the landlord's responsibility, what improvements are going to be the tenant's responsibility to carry out, and then what is the quality standard of those improvements? Are there really specific things that the tenant requires that will need to be done as part of the improvements? You'll want all of that work very clearly set out. And that's normally kind of attached to the schedule. There'll be a schedule of landlord improvements and tenant improvements, an agreement between the landlord and tenant about what the unit is going to ultimately look like once you actually start using it for your specified use. Insurance provisions. Have you spoken to your insurer about what is reasonable insurance? Your landlord will likely have a lot of requirements about the kind of insurance that you should carry, and insurance can be very costly. So you should get an opinion about whether or not that makes sense given your proposed activities, whether or not your insurer thinks it's reasonable, and it's a point that you can negotiate with your landlord. It might not necessarily be successful, but it is an additional cost that obviously organizations bear every year. So you want enough insurance to cover off liability, and the landlord will want you to have enough insurance to protect their interest in their property. But you also don't want to be saddled with too much insurance where you're just paying a lot for insurance that you don't necessarily need. And then, so surrender and term and termination. When you're negotiating the lease, you need to negotiate how it's going to end. So there are things that happen at the end of a term of the lease that are relevant in terms of costs. If you've done a lot of improvements to the space or requested that the landlord make improvements to the space, the landlord may want you to pay for removing those improvements at the end of the term and returning the space to the state that it was before the lease started. And so if that's the case, again, it's something that you need to be aware of and factor that into your bottom line if you're going to leave the premise and surrender the lease. Often what we like recommending to tenants is that they only agree that they'll remove the improvements that are maybe non-standard, so improvements that no other tenant might make use of, or that they only remove the improvements that haven't been approved by the landlord, so were installed without the landlord's consent. So that way it minimizes the cost in terms of giving up the lease when you decide to leave the space. And then term and termination. So most commercial tenancies are for a fixed term, and there's a business reason why there is a term, and it's expected that the tenant is in the premise for the entire term. So if you do anticipate that maybe your funding will change, maybe you won't necessarily have the same budgetary capacity from year to year, you're going to want an option to terminate early, and that's something that you're going to need to make sure that you negotiate, because otherwise, if you don't have that option to terminate early, the term of your lease is what is set out in the lease, and you don't have an option to leave earlier without being responsible for the rest of the costs in the lease, or being responsible for damages to the landlord because you left early and they have to pay to redo the premise, to find a new tenant, and all those things. So if early termination is something that's important to you, then I would make sure that you set that out clearly when you're negotiating the lease. And then registration of the lease. So this is really something that matters if you're in the space for a long time. So, maybe 10 or 20 years is the term of your lease. Or if you think that the landlord's planning on selling the building. Registering a lease means you register a notice of lease on title to the property, so with the land registry. And it basically gives everybody else who's looking at the property notice that you have an interest in the property that matters and that's binding. So you need to, at that point, so if you think that this is going to be an issue, say that the landlord's selling the building and you want to make sure that a potential purchaser knows that you're in the space and you have a right to the space for 5 or 10 years, or if it's just a long-term lease, it would make sense to have a right to register a notice of lease on the property, and that's something that you're going to want to negotiate at the outset.
So Shalina, we have a question here that I think is kind of timely with your presentation.
Sure.
Susan Stewart is asking, what happens after you unexpectedly have to leave early?
So again, if you have to unexpectedly leave early, but you don't actually have like an option to terminate the term of the lease early in the lease, theoretically, you're responsible for the balance of the lease. So the balance of all the rent payments and all the costs. Now, the landlord does have an obligation, and it's a legal term. It's called an obligation to mitigate their damages. So it means that they actually have to make efforts to find someone new to go into the space, and basically minimize the amount that you leaving the space early is going to cost them in terms of revenue. But you would be on the hook for any additional costs that they've incurred and basically the rent that's outstanding until they find someone new to take over that space. So that's why it is really important to have kind of an out if you want to have an out. And I like the one-way kind of out for tenants. So if you're a tenant, I wouldn't say this, you're a landlord, but if you're a tenant, I kind of like the option to basically have the tenant decide if they want to leave early, but not the landlord decide that they want to terminate the lease early. Because that means that there's some security for the tenant, and it's, better control for the tenant over basically their business arrangements and their leasing situation.
So on that same note, we'll just take one more follow-up question from Susan, I think, at this time.
Right.
And I think it's something that a lot of arts organizations do when they rent spaces themselves, but they also sublet. So Susan's followed up with, should you negotiate the option to sublet in your space?
That's a good idea, and often options to sublet will be included in a lease, and they'll kind of be an option for the landlord to just terminate the lease and have a new lease with the person that you're proposing to sublet if that's what they want to do. So some landlords will allow you to negotiate that, and if that's on the table, then I think it's a good idea. So it would be an option to sublet or to assign the lease to another party. And the landlord would generally want you to basically provide some sort of confirmation of creditworthiness of the person that you're subletting or assigning the lease to. Now, the problem with the sublet is that for the tenant, you're ultimately going to be still responsible under the lease because you're not actually terminating the lease agreement and handing it over to another party. So if your subletter defaults or does damage or doesn't leave the space appropriately, then you're going to be on the hook. And Susan, I'm answering your question because I can see it. So you're going to be on the hook with the subletter. If you assign the lease to another party, generally as part of an assignment, that other party is basically taking over the lease, and your obligations under the lease and your rights under the lease are going to be terminated. So that would be the difference between the two of them. So an assignment in terms of if you don't want to re-enter the space at any point, if you don't want to have any further rights to use the space, probably makes more sense than a sublet, which leaves you with still a lot of liability under the lease because your role under the lease is not terminated. There's just an additional party involved. No problem. Okay, so that's all of the things around negotiating the lease. So when all of those things have finally been negotiated and you have a lease agreement, I mean, that's really the hardest part. After that, it's just occupying the space, and you occupy it in accordance with what the agreements are that you've made with the landlord. So some of the tenant obligations are obviously pay on time. But I say obviously, but this isn't actually obvious to a lot of tenants when they're dealing with disputes over additional rent, which, as I said before, is a pretty common dispute that tenants have with their landlord. If a landlord tells you that you owe additional rent, unless the lease says that you're not, and this I've never actually seen this successfully negotiated into a lease, but unless the lease says that you don't have to pay that additional rent if you're disputing it, you still need to pay the additional rent and follow through with your dispute with your landlord about the amount and come to a resolution. Just because you're disputing the amount doesn't mean that you don't need to pay it and that you don't need to pay it on time. Your landlord can terminate your lease because that would be considered a default unless it's explicitly set out in the lease that you don't have to pay your additional rent if there's a dispute. So pay on time is very important. Make sure that you're using the space in line with what the lease says. So, I mean, as I said, that seems obvious, but if you want to take on additional activities that might not be encompassed by the use that you agreed to in the lease, then you might not be using the space in line with what the lease says. So you should be thinking about that in terms of all new activities that you develop or take on as an organization when you're in a leased space. Access by the landlord. So if the landlord, your lease will set out their access rights. So make sure that you actually have provided the landlord with access rights. Don't block the landlord's access if they're doing it in accordance with the lease. If they're not doing it in accordance with the lease, then of course you don't need to provide the landlord access, but you need to follow what the lease says. And then this obligation to occupy. So many leases will have an obligation for a tenant to use the space to be open for business and to occupy the space 5 to 7 days a week. And so you need to make sure that you're actually in the space, occupying the space, and using the space in accordance with what the lease sets out. And then no removal of equipment and trade fixtures. So this one really relates to the Commercial Tenancies Act, which is that piece of legislation I mentioned at the beginning of the presentation that sort of applies, but you can contract out of a lot of things. But what the Commercial Tenancies Act does allow the landlord to do is if there is a default by a tenant under the lease, if they're not paying, the landlord can take possession of not only the space, but of the tenant's property and basically use that property and dispose of that property to pay outstanding debt. So most, if not all, leases will have a requirement that the tenant cannot remove its equipment or its trade fixtures, so anything that's specific to its business or its use of the space, because that signals to the landlord that maybe there's going to be a default, that there would be nothing for them to rely on in terms of collecting any rent owing or any other costs owing. And so that would be a general default under the lease. So it's important to not do that. And then your maintenance and repair obligations. So you're going to have certain maintenance and repair obligations that you need to take care of in the space, and you want to make sure that you're doing it in line with the standards set out in the lease. And if you require the landlord's approval, or if you need to provide the landlord notice that certain items need repair or are going to be repaired by you, that you do that. Okay, and then what are the landlord's obligations? I mean, the landlord does have obligations. So quiet possession. So they need to basically leave you alone. You've acquired the right to use the space exclusively, and so you have a right to quiet possession, and the landlord shouldn't be interfering with how you're using that space if it's in line with how you said you would use it in the lease, or interfere with your customers, your students, anyone else that you invite to use that space. So the landlord basically has to stay out of your business if you're carrying out business in accordance with what you agreed to in the lease. Capital repairs. So this really should be a landlord obligation. I've seen it snuck into a few leases by the landlord, but it's something that you should be aware of. The landlord should really be making all capital repairs on the building and the lease space. So replacing roofs, repairing foundation issues, replacing HVAC systems, replacing elevators. Those are all capital costs and capital repairs that come with owning a building and are really costs that the landlord should be bearing. They sometimes try to sneak in things in the lease, so you want to make sure that that is really their obligation and they pay all the costs associated with that and are responsible for all the work associated with it too, because as a tenant, you don't want to be involved in doing any sort of capital repairs that might affect the building as a whole. That's, kind of a slippery slope. And then maintenance as per lease. So if the landlord is obligated to clean the space or to clean the common areas and to maintain them to a certain standard, then you want to make sure that they're meeting those obligations as they're set out in the lease. And then common areas. So as I mentioned before, obviously you'll want access to certain common areas, bathrooms, stairwells, elevators, but also you'll want to make sure that the landlord ensures common areas allow people to access your space in an accessible way. So everyone, no matter what their ability is, can access the space because that is now a legislative requirement. So that's an obligation that you're going to want to make sure the landlord is responsible for.
Shalina, Susan has a really good point about what if there's no mention in the lease about cleaning and your tenant doesn't clean or your landlord doesn't clean?
Then, it's a problem, but it's not necessarily something they're responsible for under the lease if it's not mentioned in the lease. Presumably, they'll want to keep the common areas clean because it's in their interest, but not always. So if that's the case, it's something that would likely be a dispute with you and your landlord. You might need to get creative about how you interpret the lease and the landlord's obligations. But how you deal with common areas should really be explicitly mentioned from the outset and agreed upon between the parties from the outset.
Gotcha. And if you have time, because we've kind of already talked about capital repairs, what are your rights if the commercial landlord is not making repairs to the building?
So again, your rights are going to be set out in the lease itself, and normally that would be considered a default. So if the landlord's not meeting its capital repair obligations under the lease, so maybe the building's not safe, even maybe it's just not being properly maintained to the standard that's set out in the lease, which would just be a commercially reasonable standard, you can terminate the lease because that would be the landlord's default. So if there's a default under the lease, there's normally a provision in the lease that says, if the tenant defaults, then the landlord can terminate the lease upon 30 days notice. Or if the landlord defaults, the tenant can give 30 days notice to terminate the lease. So that's your option if they're not making the repairs that they're required to in the lease.
Got it. All right, so let's, I see a couple people are typing. We will have time for questions at the end.
There's one more slide, so I think we have tons of time for questions. Okay.
Got it.
So, okay, and so then the last slide, so terminating the lease. So we, again, discussed this all as part of negotiating the lease, is that you need to think about how you're going to terminate the lease. So do you have a right to early termination? And if you do have a right to early termination, make sure that you follow the specific provisions provided in the lease. So if early termination is tied to, say, getting funding or providing proof to the landlord that your funding wasn't renewed, you would need to provide the landlord with evidence of those budgetary restrictions or evidence that funding wasn't renewed that you were relying on to stay in the space. If you terminate early, you'll want to enter into an agreement with the landlord to surrender the lease. And this is important because there are ongoing obligations under the lease until it actually terminates. So if you're terminating the lease early, meaning not at the end of term as set out in the lease, you want to surrender the lease. Basically, you and the landlord want to be released from all obligations and rights under the lease, so it comes to an end and it's clean and both parties can walk away and be certain that they don't have any further obligations to each other. Again, if you're leaving the space, you want to know what you have to remove. Generally, you'll have to remove your equipment, your trade fixtures, all of those things. But do you have to remove walls that have maybe been constructed to separate the space into different rooms or offices? Do you have to remove lighting, flooring, things like that? How does a space need to be before you leave so that you can lastly get your deposit back and not be on the hook for any further cost to the landlord? So those are the key things that you should think about when you're terminating the lease and surrendering the premise. And that's all I have, so I'm happy to take questions.
Yeah, so thanks, Shalina. That was great. We do have a couple. I know Susan Stewart has a follow-up question, so we'll start with that one, and then we'll get to a couple more. So
Sure.
This is a great opportunity for anyone that has questions or has had them throughout the presentation to write them down in that chat box and right at the bottom of the meeting. So we can get started with a question from Susan again. Usually the landlord creates the lease. Wouldn't adding your own requirements to the lease lessen your likeliness of your option to be accepted?
So yes,
I think she was
I understand the question. So yeah, usually the form of lease will come from the landlord, but that doesn't mean that you need to accept everything that the landlord has set out in the lease. And it is a business arrangement. It's a competitive rental market. I understand that. So a lot of tenants do feel like they are forced into taking on terms from the landlord that might not necessarily be the most favorable terms. You do need to decide whether or not you as an organization or as tenant can handle those terms, can handle those costs, and are okay with being responsible for those items. So if the space is just the perfect space and you really need to be in it, obviously you would negotiate less things, but it's still important to understand what those specific negotiating points that I set out mean for you and what the landlord is actually asking for, because it just gives you a full picture of basically what you're going to be on the hook for, and that's important as well, even though you might not be able to change them, because the landlord does have the negotiating power in a lot of circumstances, and especially in Toronto.
Our next question is from one of our guests. Can you elaborate on what landlord obligations are in terms of buildings being accessible? Is this something that is being grandfathered in, or does it apply only to businesses of certain size or uses? They are asking because they're trying to get their landlord to make their space accessible, but they say it is impossible.
So some buildings are going to be grandfathered in. So the piece of legislation that's relevant for accessibility is the Accessibility for Ontarians with Disabilities Act. So some buildings, and again, this is likely more of a legal question about whether or not this actually does or does not apply to your landlord and that building, but some buildings will be grandfathered in. But for the most part, people need to make efforts to make the space accessible. So if that's an issue that you're having with your landlord, I would say that it's worth looking into and worth seeing what their actual obligations are as a landlord under that piece of legislation. Because the idea behind the legislation is that it's important to make things accessible, and the government doesn't want to provide a mechanism for people to make excuses to not do that. So my opinion is there aren't a lot of exclusions, but that's more of a fact-specific question that you're going to need to explore with your specific landlord.
Our next question is from Janet, and she's asking, what should be taken into consideration if there are multiple organizations, i.e. partnerships, leasing the same space?
So this is where the idea of a license comes in that I briefly mentioned at the beginning. My recommendation would be that generally you want one organization that is actually a tenant under the lease with a landlord, and that then enters into licenses with other organizations to use the space. So basically that tenant, has the right to exclusively use the space, but it can enter into a separate agreement and license parts of the space to different organizations at different times even to carry out activities. So it would kind of be on a chain where there'd be, the lease and then a license agreement. Some organizations, if they're basically leasing like an entire building from a landlord, there would be a head lease and then a sublease, where basically the head lease would be between the owner of the building and the organization that, has leased the entire building, and then a sublease between that organization and the tenant. So, and the subtenant. So it would really depend on what the final arrangement is and what it looks like, and how separate and segregated the different spaces that different organizations are going to be using are. But there are different options to explore if that's the situation that you're in.
Susan Seward is asking, where can we find examples of contracts we can use as templates if we are sharing an art space or renting a space, and head leases and sublease examples? I can certainly say Work and Culture actually has an example on their Space Finder Toronto section of their website. There's a great rental agreements and best practices there as well. So we'd be happy to include that in the email that we send to everyone. But over to you, Shalina, to answer it further.
Well, I mean, obviously different law firms have their own templates. So your lawyer might be able to provide you with something to work from. But as lawyers, our recommendation is always that even if we give you a template, that you do have a lawyer review it, especially because you're going to make changes to it and we can't necessarily tell you if it's legally binding or not. But, I mean, Google, it's always my quick answer. You can find agreements, full-on legal agreements on Google. And again, I don't know, and without having someone vet them for whether or not they're enforceable in Ontario, whether or not they meet your specific needs, I can't say whether or not they're good, but it's certainly a starting point. But I will say this, and not to be a plug for lawyers, because I know we cost money and a lot of organizations don't have the money, but in my experience, I do think that it's better to go to your lawyer first for the template that they prefer to work from, and go from there, because oftentimes clients will come with lease agreement that they prepared based on a mishmash of things that they pulled from the internet or from other sources or from other organizations, and it actually spends more time, is more costly to then review it and figure out how to change it and make it consistent than just starting from scratch with a template that your lawyer uses to begin with. So that would be my answer, and hopefully not too biased answer on that.
Yes, no, I think that makes total sense. I think for arts organizations, kind of getting an overview of where to start and what it looks like is also important, and then lawyer, obviously, important too. So Stephanie Draker from Work and Culture is in the chat box right now, providing great examples of those lease and contract agreements from Artscape as well as their website. Do you know of any offhand, I'm just looking at Jennifer Watkins' question here, of any contracts for renting performance facilities that are kind of lying around on the internet, or would that be something that we go for Google?
Go for Google, but Stephanie did point you to Artscape, and Artscape does do events rentals and things like that, so they might be a good resource. And I know that they, are willing to share resources to help arts organizations and artists individually with these types of business things and legal arrangements. So they would be a good contact point as well.
Excellent. All right. Does anyone else have any questions they'd like to ask during this time? I see Christine, you're typing. Give it another minute or so and then wrap up.
Sure.
Oh, Christine has asked, if your landlord is not repairing the facility and you do not want to end your lease, are there any other options? Ooh, a difficult position.
There are. They're costly generally. I mean, you would want to go to court. Basically, the quick answer. You can bring an application, basically for an order from a judge saying that the landlord has to comply with the provisions of the lease. That's a possibility. I'm not a litigator, so I don't know the intricacies of doing that, but I know that it's been done. But it costs money, and it might actually cost less money to just terminate and find a new space, to be honest. But if you have a really great deal, then maybe it's worth it.
Yeah, case by case for sure.
Yeah.
Susan, I see you have a question. Carfax has free legal services. Yes, they do. I have taken my contracts to them and they have advised me pro bono. So we will also include that. There's and a few other links we have, Susan, in our follow-up materials, in addition to staff's links here from Work and Culture and Artscape. So do you have anything to add to that, Shalina?
And I also believe, and I know that Pro Bono Ontario, Pro Bono Law Ontario was launching a project to help nonprofit organizations with issues like that. So I'll see if it's actually launched, because they also will be a good resource. They have lawyers like me who volunteer, you know, on a day-to-day basis to answer questions from nonprofits. So I'll check in and I'll send that link to Stephanie if the project's active.
That would be great, and then we can include it too in the materials. It looks like there's no other outstanding questions right now. So thank you again to Shalina and Steph and Work and Culture for putting together this webinar. It was very informative for us and our arts organizations. You can check out more upcoming learning series webinars on our website at artsbuildontario.ca. But please join us for a next one happening tomorrow afternoon at 12 p.m. on Capital Project Success, stories from the Ottawa Art Gallery and First Ontario Performing Arts Centre. So you can find that on our website at artsbuildontario.ca. Thank you, everyone, and we will be in touch with our survey, with the recording and the follow-up materials we discussed today. Have a great afternoon.
Thank you.